most of you know, my name is Gerard Kennedy. I am a faculty member at the University of Alberta's Faculty of Law, where I mostly teach and research in areas of civil procedure and administrative law. I was not supposed to be here today. Malcolm Lavoie was supposed to be moderating this panel, and then he had the thoughtlessness to get appointed Alberta's Deputy Minister of Justice, handing the reins over to me. But I am actually extremely happy to be here with my esteemed co-panelists as we discuss the common law protections of rights. Often the Runnymede Society talks a lot about the Constitution and statutes and relationships between them, but there is a rich and interesting history of common law rights protection, which we hope to have a good discussion with the three people to my left today. Dr. Michelle Gallant is a full professor at the University of Manitoba's Faculty of Law, where we were colleagues until a few months ago, and which something I miss enormously. She teaches and research in areas of tax, philanthropy and the law, money laundering, terrorist financing. She's been a member of the Manitoba Law Reform Commission. In a previous life, was a tax lawyer for the Department of Justice. We'll try not to hold that against her. Then we have Paul Warchuk, new faculty member at the University of New Brunswick's Faculty of Law, where he mostly teaches and researches in areas of administrative law. He previously clerked for Justice Suzanne Cote at the Supreme Court of Canada, has a JD from Queen's, an LLM from Harvard, from fake Cambridge, and then his PhD from real Cambridge in England. And lastly, we have Sam Beswick, assistant professor at UBC's Peter A. Allard School of Law, where he teaches and researches in areas of torts, unjust enrichment, remedies, private law theory. He has his original law degree from the University of Auckland, which you will not be surprised after you've heard him spoke for a second. He clerked at the High Court of New Zealand, has LLM and SGDs from Harvard Law School. So that, I guess, I'll start, and I'll turn it over, and I'll start with Michelle. So you've written about common law concepts of res and in rem liability. And I guess I'm going to start, because we talked about the relationship between common law rights protection and statutes. What are these concepts? What are their history, and how do they intersect with modern statutes?
Sure. Well, you know, the idea of in rem has sort of seen a reanimation in the modern context. So. In rem liability, or the liability of the res, you might be familiar with that. It's sort of an age-old idea, largely derivative from the context of maritime and admiralty law. Res meaning in Latin the thing, right? And when we talk about in rem liability or in rem jurisdiction, meaning the extension of jurisdiction on the basis of control over the res, so you have control over the thing, and that gives you the jurisdiction to conclude a particular matter. So that has long been sort of a piece of, like I said, a piece of admiralty and maritime law. However, since probably around 2001, this idea, the idea of the liability of the res, has become a central, if not the central piece of going after what you might call it profitable crime, financial crime, proceeds of crime, dirty money. It has become, the idea of the liability of the res has become the central idea. So what you saw in Ontario beginning in 2001, there was a particular law that came in which basically said, look, you can bring an action to sue a bag of money. And then a couple of years later, it became, well, now actually under this law, we're going to call this law, this is an action in rem. And you've seen these actions emerge across the country. I think everywhere except Prince Edward Island and Newfoundland now has a law. And the law is aimed at sort of confronting, as I said, the financial dimension of crime, whether that be proliferation, whether it be tax evasion, no matter what it might be. But it's grounded on this age-old common law concept, not of the liability of a sentient human, not on the liability of sort of in personam, proceeding through the person, but on the basis of the idea that this thing can be held accountable.
All right. Thank you very much, Michelle. So, Paul, you've written a lot about the Annapolis decision and de facto expropriation. the law of which was definitely not changed in the Annapolis decision, according to the majority anyways. So I'm wondering how you think it contributes to the history of common law rights protections, particularly in the realm of property.
Right. So, well, first, as you mentioned, I'm a new professor. So I have to do this little academic thing, which is say, there's actually an academic debate about what we call this area. Do we call it de facto expropriation, or which a lot of academics do, or do we call it de facto taking, like the minority wanted to do in Annapolis, or the new term that we have from the majority is constructive taking. But regardless of, the label we apply, what we're talking about is when government regulates property to the extent that there are no reasonable uses left for the owner, without actually taking possession of the property. So obviously in this area, common law rights are really important because there's no charter right, as we all know, no charter right to property. And similarly, it sort of falls through the statutory protections through the cracks because it's not covered by expropriation acts. So the common law is sort of all we have. And I think the Annapolis decision really does two important things for common law protections, and as you said, in particular, the common law protection for privacy. I keep saying privacy, but I mean property. I'm sorry. So the first thing is that it acknowledges that there is this cause of action for constructive taking, which is something that I argued for 8 years ago, but academically it was uncertain. And now after this decision, I have emerged victorious. It is now established, no one disputes, at least in the articles that have come out so far, no one disputes that it is now established there's a common law right to compensation when the government constructively takes your property. And so obviously from a property rights perspective, this is a good win that you don't have to, rely on a statutory remedy. There now is a common law action. The other big change, which is much more controversial, is the how do they put it? The clarification of the old test that you alluded to. So in order to establish a claim for constructive taking, the CP Rail case set out sort of two requirements. The plaintiff had to show that the government took a beneficial interest in the property, and then that all reasonable uses of the property were gone. And so in Annapolis, the majority kind of explains that when we said a beneficial interest, we didn't actually mean beneficial interest in the equitable sense of the phrase. What we mean is just a general advantage. And so this sort of greatly, well, depending on who you ask, what the meaning of advantage is versus beneficial interest, it can sort of expand the scope of things that meet the first step, and thus shift the focus really onto the second step of the test, which is the deprivation of all reasonable uses of the property. And so from a common law rights perspective, it seems like this is more treating property like a right, in the sense of when we talk about rights, we focus on the right holder and what's the violation of the right, rather than what the violator gains from violating or infringing the right. But this aspect of the case, as I said, has been somewhat controversial because people think, well, this shifts the balance between public and private interests. The public interest being represented by the government regulating body. Generally, in this realm, it's zoning and planning regulations. But anyway, so yeah, those are the two main sort of points that I took away from Annapolis in terms of how it affects common law rights and the right to property.
Okay, thank you, Paul. I'm going to resist the urge to ask a follow-up question because we'll be able to circle around again, and I'll go over to Sam. So Analysis, by way of background, this panel was partially conceived as an offshoot of a conference that Malcolm and I co-organized last summer in Banff on the rule of law and private rights, to which you contributed. And you wrote an article that's now about to be published in the Supreme Court Law Review that comes to tort law and specifically the civil liability of the police. And you could explain how in the US, there tends to be a presumption that we're going to start from analysis of state or officer immunity, and then place the burden onto plaintiffs as to why no immunity should apply. Whereas in other common law jurisdictions, there's a presumption of, I think you call it, of equality, where the police can be presumptively held liable, but there are nonetheless, maybe more de facto carve-outs, but the presumption is they're going to be liable. So I guess what's significant about the difference in doctrinal approach, and does it actually make a difference in practice? Because
Sure.
one could think it might not be.
Thanks, Gerard. Well, so as you mentioned, I did spend some time living and studying in the new Cambridge. But it was,
When I was there, it was called the fake Cambridge. But
but I found America to be quite a foreign place, and I learned a lot as a student there. And one of the things that struck me as foreign was the way that people and lawyers talked about the civil liability of police. When an officer used, for instance, excessive force on somebody, it was intended to be characterized, or is characterized, as a civil rights violation. It's maybe a constitutional tort, it's a breach of constitutional rights. Whereas for me as a private lawyer coming from New Zealand, my first thought, perhaps antiquated, is that it's just battery and maybe false imprisonment. And so there was a puzzle there for me, and I wanted to write a paper, and I wanted to look into, well, what were the fundamental principles that seemed to drive what I thought to be this divergence in legal approach, and also related to that, does it make a difference? And my inclination, and what I wrote about, is that there is a fundamental principle that drives these cases in Canada and in other common law or Commonwealth jurisdictions, and that's the Dicey principle of equality under ordinary law. So Dicey writes famously, "The rule of law requires the equal subjugation of all classes to the ordinary law of the land administered by the ordinary law courts." And he grounds his equality principle in the great case of Entick and Carrington, and in other cases, and it's been reaffirmed in cases like Collins and Wilcock, Lord Goth, and others. And the equality principle, this principle really has two features. One feature is equality, that is, public officials, police officers, should be treated as equal defendants as any other defendant would be treated. And then the other feature of it is the ordinariness feature, which is the common law is a mechanism for holding them to account. And so what that means in practice is if I can take an example from a case from Ontario recently, a case called Almaradi and Pat. What that means in practice is if, say, a police officer racially profiles a man who's just walking down the street, the officer cuffs him and punches him in the face for no reason, or for no good reason, well, that plaintiff can sue. That plaintiff can sue the officer for battery, false imprisonment, and yes, breach of their charter rights. And the officer and the public authority who stands behind the officer is going to be liable in tort unless they can point to some positive lawful authority that they have for making the arrest, punching the man in the face. But the burden falls on that officer to prove that they have a defence in the same way as the burden falls on all defendants to prove that they have a defence to tort liability. And yes, the law provides certain carve-outs, for instance, powers of police to make arrests, but they have to be able to point to those powers. Now, that presumption of equality is not how things strike me as operating in the United States. Instead, police liability cases are driven by a complex array of federal and state and municipal immunities that attach both to the officer and to the public authority entity. Accordingly, I won't go into the details. You can read the very, very, very long paper. But what that means is in practice is when these cases go to court, there's this additional hurdle. First, you have to show, as the plaintiff, that an immunity doesn't apply. And so if you'll allow me to take it, it's sort of an equivalent case that reached the US Supreme Court twice, a case called King and Brownback. Law enforcement officers in that case brutally beat, according to the facts of the case, the alleged facts of the case, brutally beat an innocent college student in broad daylight on the street. It's caught on camera. You can see the footage of it in the related news article, because they mistook him for somebody else. And through various applications of immunity doctrines and procedural hurdles, the plaintiff found himself ultimately without any recourse through the common law route or through the constitutional route, even though it might seem like a pretty clear case, like in the El Maradi case, of a clear, to me at least, battery and false imprisonment. So I think that it does make a difference in practice where your starting point is. If you start with a presumption that everybody should be treated as equal defendants under the law, the burden then falls to the defendant to prove the legality of their actions. Whereas if you start from a presumption that certain defendants get immunities that others don't enjoy, then certain plaintiffs will find themselves without recourse before the courts.
All right. Thank you, Sam. You referred to your very, very long paper. I do have some recollection it didn't comply with the word count we gave you. But it was well worth it. Again, I will resist the urge to ask a follow-up question for now, because I'd like to bring it back on to Michelle and maybe put my procedural law nerd hat on for a moment. So you've done a lot of work about tainted property and proceeds of crime. And this often comes up with issues, intersects with common law doctrines such as abuse of process and issue estoppel, as we resolve these public law determinations that something's a proceed of crime in a subsequent property dispute. So I'm curious how these various common law doctrines intersect with each other.
Do you know, originally when I agreed to speak today, I said, well, there was this theme, and so issue estoppel and res judicata were all coming up in the confines of this new in rem mechanism. But what I realized is, yeah, the language is coming up for sure, but it's never successful. So I'll speak about that anyways, because the idea would be, so these regimes, as these sort of res-based regimes, they're called civil forfeiture. I suppose that's the fancy language. But a bunch of years ago, the Supreme Court of Canada had one constitutional case, and won't talk about that, but they basically said, look, for some of these regimes, because you might have, so they usually, you would have, say, a criminal action, and that would have been successful or not, and then there'd be this subsequent civil proceeding against the thing, right, against the money or against the thing that was used in connection with the crime. And the Supreme Court of Canada said in that case that, look, that there's the possibility that the civil proceeding, the in rem, could interfere with sentence. And the court said there, it's like, don't worry about it. We have these doctrines, these common law protections. We have abuse of process. We have issue estoppel, considerations of res judicata, and those can be used to sort of prevent or deny that particular interference. So if you look through the jurisprudence, yes, they do pop up. In one particular case, the issue estoppel was successful, but by and large, they're not actually successful in terms of sort of trying to rein in this particular device. And to give you a sense of how broad this device could be, it's that when we think about it as a device that targets property, so it targets property. Most of us do our taxes. Most of us do our taxes in our house. It's a crime to evade taxes, right? There's a tax crime. If you sit in your house, do your taxes, and intentionally, deceitfully include some item of income, under this regime, in rem liability, your entire house becomes liable to what's called in rem forfeiture. Your house is, in that speaking, it's the instrument, it's the res on which the crime has occurred. So it becomes liable to be taken under this. So when you think about it, it's like, wow, the potential interference with property rights is huge. But let me just talk a little bit. So when I say these doctrines, which my colleagues asked me, the issue estoppel and res judicata and abuse of process, where had they come up? There's a Manitoba Court of Appeal decision where somebody argued, again, there was a criminal proceeding and that it was followed by a subsequent in rem action related to certain property. And one of the interesting things that is sort of said there and that's sort of repeated by other courts is that, well, look, even if sort of the owner of the property, so in the first case, you have a criminal proceeding against John, and in the second proceeding, it's against John's stuff. But what they've ended up saying there is, look, these aren't, those doctrines don't apply. Why? Because we don't actually have the same parties. In the first one, you had a criminal action against John, and in the second one, you have a criminal action against the boat, not John the boat. So the parties are not the same. So you sort of see, you've seen that percolating. But one of the places, so there is at least, so there's been a little bit of hope, I suppose, for some of these common law doctrines working. And the one place where they have worked is, you will know that under the criminal code, there's what's called section 490, which basically says, look, after a criminal prosecution, if there's property, right, that was relevant, that was evidence, or it's before the court can make an order as to who that belongs to. And there's one particular case where a gentleman was convicted of a drug offense, and his mother applied to the court saying, look, some of that money you have, that's mine. And the court ordered, said, like, that property belongs to the mother. Now, before the money was given to her, the province showed up and said, oh, but we're going to civilly forfeit it. So we're bringing an in rem action against the property, refused to pay the property to the mother. But in that particular case, the court said, no, in this case, there actually has, so to evoke the res judicata piece, there actually has been a prior determination in the criminal code of lawful ownership of that property. And that determination was made with respect to the mother, and therefore you couldn't the subsequent civil action was blocked. So it did work in that one. But one of the ones that really surprised me, because for some time I've been concerned about the, as I noted earlier, that particular, I guess, the kind of the tax dimension, because usually when people think about this in rem thing, you're thinking about drug money, right? And you're thinking of bags of cash, or now you're thinking about payment in Bitcoin, right? And can we seize those drug payments, right? Or you're thinking of, the trade in nuclear materials, which gets you a lot of money, and those kind of resources associated, instruments associated with that. But there is one which was really interesting because it's somebody who is specifically a tax case. But not only is it a tax case, it's not a tax prosecution followed by a tax civil forfeiture. It's a civil tax action. So you probably know this. In tax law, they can use tax law to sort of, it's called a net worth assessment. So basically it means that, look, we don't believe that you filed your taxes properly, so we're going to sort of broadly assess how much you owe us. So this was done. An individual was broadly assessed that we don't believe the claims you're making under tax law. We believe that you owe this amount of money. So they did a net worth assessment, which is a civil assessment, civil proceeding. And in that confines, they seized held property. And then there was the CRA, so the Canada Revenue Agency, entered into agreement and sort of settled these issues with the taxpayer and released the properties. And as those properties were released, the province brought a civil action to forfeit the exact same properties on the basis that they were the proceeds or connected to a tax evasion crime. So you can see it's stunning there. So they were bringing a civil action, same properties. The previous one was a civil action, same properties. And in that, so I was thinking, well, okay, this is going to be a case where you're going to see res judicata, you're going to see issue estoppel. It's already civil. It was the state, right? The state bringing the action. It's a civil proceeding. Surely you will see success here. And no, right? It's not successful. Well, firstly, as I noted, please note that the defendants aren't the same. So the property is not the property's owner. So that is one difference. And in that particular case, and I'm not overly familiar with all of the niceties of administrative law, but this struck me as quite, they focused intimately on one of the elements that you needed to get the common law protection was you needed a final judgment. And in this particular case, they said, so there had been no final judgment from a court. There'd simply been a settlement with CRA. And they said that wasn't enough to trigger the block. And to me, I mean, I guess in reading that, when I think about sort of the failure of these common law protections, it really was stunning to me to think on a bedrock level of the individual who's working with the CRA. You think their government, whatever we settle there, right? There's no distinction between them, particularly the federal government and the provincial government. They wouldn't see a distinction. And you would think that things had been sort of finally resolved, particularly in that particular case, because the underlying wrongdoing was exactly the same. Those property, it was the idea of a tax offense, a tax crime. So all that to say, there's like sort of a tiny ray of hope, I suppose, but not much is actually, those regimes have not sort of succeeded in the way that might have been anticipated a few years ago.
That's fascinating. And looking at some of the faces in the audience, I suspect there may be some questions on that. But in the interest of time, I'll turn it back over to Paul. So while you've taken this interest in expropriation, I still think of you as first and foremost an admin law scholar. And it's acknowledged right in Annapolis, regulations and legislation can certainly restrict one's rights in the face of expropriation. But then I guess... can this either de facto or de jure be done rather than legislation, which is normally contemplated, but through regulation? And how explicit does it have to be?
Yeah, so I'll try to provide like more hope about the common law, after that story that I was also shocked to hear about. Okay, so the starting point is there is a principle of statutory interpretation when we're interpreting these acts that purport to take property, that essentially, no taking without compensation. And so unless there's express words that are clear in the act, property won't be allowed to be taken without compensation. And so that would extend, I imagine, to regulations as well. If it's not expressly in the reg-making power that the Parliament's giving the regulation maker the power to take without compensation, it wouldn't, travel down to them. But, the interesting thing is there's a lot of these presumptions of statutory interpretation that are supposed to protect common law rights. Probably a lot of people are familiar with the presumption that we don't oust the jurisdiction of superior courts, particularly with respect to judicial review. And so when we're dealing with that presumption, the strength of the presumption, I should say, or the level of clarity required by the words of Parliament is so stringent that in the last 150 years, we haven't found an act that is clear enough to oust the judicial review jurisdiction of the superior courts. Of course, now in Canada, we no longer really rely on it. We have Crevier, but still in the UK, the principle's alive and well, and they're still struggling to find how clear things have to be. In the expropriation realm, it's really not the same story. The courts are much more willing to say something is clear and explicit, sort of in the ordinary use of those terms. And so, there are famous cases like Otherson, where the federal government, through an act of Parliament, expropriated trust funds held in trust for disabled veterans. And the Supreme Court said, well, the language is explicit, that the government intended to take without compensation, and there's nothing we can do about it. So at the end of the day, I think that's sort of, the rule that we have. I guess one further piece is, about the delegation, that when we combine that with the fact that in Canada, there's essentially no limits on what can be delegated by Parliament to administrative decision makers, which was recently affirmed in the GGPPA case, over a strong dissenting voice with Justice Cote's reasons saying, maybe we should limit things like Henry VIII clauses, where the executive is able to actually override the very act that confers the power upon the executive decision maker. But the majority didn't bite, and so we sort of remain in a position that anything Parliament can do, in essence, can be delegated down, and so that includes expropriation and taking without compensation, so long as it's done expressly. So I think that's it.
I'm glad you got to bring up Henry VIII clause. Okay, then. So, Sam, in the U.S., police officers' knowledge of the law is relevant in determining, as you note, whether there even is a rights violation in the first place, and that it can remove their qualified immunity from suit. In Canada, an officer's knowledge of the law is normally irrelevant to the question of liability, but it can nonetheless show up at the remedy stage. I guess, what are the pros and cons of both approaches, or even if you don't say pros and cons, trade-offs involved in both approaches? I suspect I know which one you prefer, but does Canada's approach leave officers less certain about their potential liability?
Yeah. So U.S. qualified immunity doctrine, it's originally a federal doctrine, or the state equivalents to it as well, but it shields public officers from civil liability to pay damages unless their conduct violated, quote unquote, clearly established law. So there has to be a law on point. And the US Supreme Court's interpreted this to mean that there must really be a precedent very directly on point that is factually analogous to a high degree of specificity, in the court's words, not mine, clearly. So just to give an example of one relatively recent famous case, there was a binding circuit precedent that said that a police officer who encounters a burglary suspect and that suspect has surrendered by lying down on the ground, and nevertheless the officer uses sicks a dog on them while they're already surrendered on the ground. A court held that that was not sufficiently factually similar to a later case called Baxter and Bracey, where the burglary suspect surrendered by sitting on the ground with his hands up, and the police dog was sicked on him. So the level of factual similarity is a bit ridiculous in many cases. And it's a doctrine that's been actually criticized across the political spectrum. So the two Supreme Court judges who are on the record as being most critical and hostile towards the qualified immunity doctrine are Justice Sonia Sotomayor and Justice Clarence Thomas. Now, this doctrine, it rests on two rationales. There's an instrumental rationale, this idea we don't want officers to be chilled and fearful of civil liability, or have that hanging over their heads, and so they need this extra qualified immunity. And there's also a fairness rationale. It just wouldn't be fair to officers to subject them to civil damages liability if they couldn't be sure that the law was on their side at the time they acted. And I don't think either of these rationales holds up, and neither is consistent with the way the law is applied in Canada and other jurisdictions. So on the instrumental rationale, scholars have, such as Professor Joanna Schwartz in the United States, have empirically demonstrated that in almost all of these cases, officers are indemnified from damages liability. So even if it's their name that is not notionally appearing in the docket, it's the government standing behind them paying these claims, and there's not a lot of empirical evidence to suggest that their actions are chilled by the threat of civil liability. And as for the fairness rationale, Will Bode, a scholar at Chicago, has demonstrated that rationale is just not consistent with the way that the legal precedent history of this doctrine emerged, its origins. But it's also just contrary to how the common law ordinarily understands fairness in these cases, which is that it's fair that the victim of a rights violation is entitled to a remedy. We don't ordinarily, in tort cases, for instance, excuse defendants just because they didn't realize or just because the law was unclear at the time they acted. Justice Sharp, for instance, in Jones and Seagay, didn't say there is a new tort of intrusion upon seclusion, but don't worry, you didn't know about it at the time, so we'll let you off this time and it'll only apply going forward. So as I say, it's a controversial doctrine even in the United States. And if you'll allow me to quote, because this judgment just got handed down a couple of weeks ago from the Court of Appeal of Texas. This is the dissent of Judge Willett in the Court of Appeal of Texas in a case called Villarreal, which I love, because he writes that in the upside-down world of qualified immunity, everyday citizens are demanded to know the law's every jot and tittle, which is true, ignorance of the law. But those who are charged with enforcing the law are only expected to know the clearly established ones. It turns out ignorance of the law is an excuse for government officials. Such blithe rules for thee, but not for me nonchalance is less qualified immunity than unqualified impunity. And we can contrast that statement criticizing the state of the doctrine of the United States with Justice Cote's vivid affirmation of the rule of law in one of my favorite, if not favorite, case of Casoian and Montreal Transit Corporation, where Justice Cote held that an officer who mistakenly arrests a plaintiff for a non-existent offence, in this case not holding the escalator handrail down to the Montreal Metro, that officer is acting unlawfully, even if he or she believes in good faith that the offence exists. The police officer, like any other person, is held civilly liable for the injury caused by another by his or her fault. In short, there are no exceptional rules applicable to the police. Those are the words of the Supreme Court in the Casoian case, and those are the words that I suggest are affirmed and reflect back the Diceian principle of the rule of law in this jurisdiction.
Thank you, and thank you for channeling Justice Cote as well. I think let's do one more round, and then we'll open it up to questions from the floor. So maybe when I get to Sam the next time, if anyone wants to, I don't know. We don't have a mic, do we?
Must do.
Anyways, well, okay, well, then we'll wait till we have a floating mic at the end. So I'll turn back to Michelle. And I know you do some international and transnational work. And so I guess I want to ask about in rem liability in international contexts. So how do we think this common law concept goes into the realm of international and transnational law, which we historically don't think of as an area that's common law based, but you think a lot of the need for it would be in that area?
Yeah, I would simply say that when you think about the original, sort of the original space within which you have sort of international law happening, would be sort of like with ships on the high seas, right? So that's where it was. So this, and trade happening. And the idea would be, look, an incident happened somewhere on the seas. How do we hold folks to account? And they developed and evolved this idea, at least in the context, as I said, of maritime algebra, because they were operating in that international space. So they would have loved to have, brought the owner of the ship to account before the courts in London, and brought whoever else was needed, brought everyone to held account in personally there. But what was happening was the ship was arriving elsewhere, and the owners weren't there. So this in rem was in rem, the liability of the res was actually very useful in asserting enforcement jurisdiction in international law. So you can prescribe all kinds of things you want, but this particular common law approach or device was very, very useful to actually enforce the law against. Now, you can say it was enforcing it against the ship. Actually, it sort of changed a bit. There was recognition that no, it wasn't about the ship, it was about getting the owner to show up and to pay damages or to account. But the bedrock idea, as it emerged, was as an international device. So when you think about this in rem, the liability of the res now, you think about criminal activity crossing a boundary, but particularly criminal activity that has a financial piece to it, right? So you would advise anyone, if you're going to commit some criminal act and you get some money, put it offshore, right? Put it elsewhere. Because the simple idea is that when we're going after your property, it's very, very difficult to negotiate beyond the boundaries of Canada, right? You have to go through, you have to have the double criminality, and you have to ask for permission and blah, 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 blah. So it's very, very difficult. So when you think of the utility of this particular device, all that you would need, right, to sort of land in the province of, be it Ontario or be it British Columbia or be it, Alberta has the same thing. All you would need, it recognizes that this liability, right, the liability to forfeit those resources, that property, that boat, or simply that bank account, right, it recognizes that once the thing touches in the province, or the property is located there, and it recognizes that the laws recognize that the offense can commit elsewhere. But so in terms of enforcing a strategy, a property-based, finance-centric strategy in an international context, it's extraordinarily efficient. I don't have to sort of talk at all about, you'd be familiar with all of the difficulties in sort of trying to bring someone to account in a criminal court, because there's a mix of jurisdictions involved and all of the politics around that. And I'm not saying there's not politics around the enforcement of this, but in that particular setting, it has an extraordinary sort of instrumental, a particularly instrumental value. And, even when you move sort of beyond that, you begin to think of a digitized currency, which actually I'm very afraid of. But I would simply say this: when you talk about focusing on where that property is, right? So in digital currency, moving around, or where your Bitcoin actually are, I said bank accounts, right? So bank accounts is one thing, but when you talk about the ability to sort of seize property, which I'm going to understand that intangible property such as any kind of sort of cryptocurrency might be, the capacity to sort of seize that merely as it transits through a jurisdiction, because that transiting in an international sense, right, the property momentarily passes here, would be sufficient to ground that in rem taking, right, and ultimately bring the action to find out on a balance of probabilities. That's the only test. On a balance of probabilities, does this particular terrain or Bitcoin connected to some kind of offense?
Okay, thank you very much. So Paul, what do you see as the effects of Annapolis that are playing out post-Annapolis? We've talked a lot about the theory, what happened, but here we are a couple of years later. What's going on?
Yeah. Maybe even some people on this panel might have different views than me. But so essentially, Annapolis has been out for about a year now. It came out at the end of 2022. So yeah, about a year. And already there's been at least 3 academic papers criticizing it. I know there are some coming out too that are more in favor, and sort of the theme between these critiques is the Supreme Court's opened the door to litigation against municipalities in particular, and other regulators, by removing the requirement, by altering the requirement for there to be a beneficial interest, and explaining that a mere advantage will do. Because when the Supreme Court gave examples of what an advantage is, it said stuff like zoning a property as a conservation property or a heritage property might be adequate to be an advantage in and of itself. And so, the sort of criticism has been the floodgates are going to open. I took a look at all the reported cases, and there's about a dozen so far that have looked at Annapolis. The interesting thing is there's sort of a division between courts that are staying the course and sort of strictly interpreting what constitutes an advantage, and then there's another group that is more generously interpreting the term advantage. And the division actually lies in the cases that are actually applying an action, the test in the context of an action for a constructive taking, or taking a more strict approach, and the cases where the constructive taking analysis is sort of in the background, they're taking a more liberal approach. So I'll give an example of, well, when would a constructive taking test be applied if you're not bringing in action? There's a recent case of Dalhousie against the Halifax municipal government for a judicial review of a decision to designate one of their buildings as a heritage building. And in the course of conducting the judicial review, and in the course of doing the Baker test for procedural fairness and the context of what procedures are necessary, the judge says, well, an important piece of context is that what happened here constituted a constructive taking. And the judge went through the test and said, by zoning it as a heritage building, Halifax is getting the advantage of this aesthetically pleasing building standing. On the other hand, Dalhousie has lost all possible uses of the property because it's contaminated and financially just doesn't make sense to go through the cost of decontaminating the interior of the building, so there's no reasonable uses of it left. And so the court said, yes, this meets the test, and that affects how much procedural fairness is required when designating this building to be a heritage building. And there's also a case from Manitoba where they're dealing with flooding, and whether flooding constitutes a taking of property in terms of when they open, I'm not sure what it's called, the Red River Floodway, to kind of protect Winnipeg, and so then other people's properties are flooded as a result. And again, there's a statutory mechanism, but in the background, the court interpreted, what's going on here and said, by flooding one group of properties and saving another, the government is getting an advantage, and so it would meet this requirement too. So, those are the cases that are taking the broader approach, but in actual actions, I'm not seeing at least a greater probability of success after Annapolis. So maybe the floodgates haven't been opened as far as has been suggested. And then also I should say, whether you think that's good or bad from a policy perspective, that's a separate debate as well, but yeah, so I would say we still need more time, I guess, to see, what transpires. But the key point is going to be how lower courts interpret this government obtaining an advantage from the regulation.
Well, having lived on the right side of the floodway, I'm not unsympathetic to what Manitoba did, but I'm also not unsympathetic to the people whose properties was just on the wrong side of the property. All right, Sam, one more question and we'll open it up. So you have indicated, I think it's fair to say, skepticism of the American approach to qualified immunity. But what, if you had to give the best justification for it, what would you think it would be, and what do you think maybe the future in both jurisdictions?
Sure. I mean, so the best justifications have been given by a lot of people and by the courts, and they're the fairness and the deterrence arguments. And I don't think that they hold up, as I say. So the same arguments were tried in the great Home Office and Dorset yacht case that I'll be teaching this week, Noah. Mm-hmm. And what Lord Reid said in that case, when he encountered these arguments that civil liability might deter officers from doing their jobs, he said, well, my experience leads me to believe that Her Majesty's servants are made of sterner stuff. And the argument hasn't reared itself too significantly since, as far as I'm aware. In terms of the implications, there is a growing trend, I think, amongst American scholars and lawyers, recognizing that the constitutional torts don't seem to be working or have been so cabined by qualified immunity, and that perhaps they should turn back to common law liability. And I think that the Canadian precedent and precedent from other common law jurisdictions can be reassuring to them that should be a viable option. That would be an implication for the Americans. I think an implication for Canadians, I would see the American illustration as perhaps a warning to those who would say that when we're talking about the public authority liability, tort law plays no role, and the Charter and other public law exercises can do the work. And I think that what the position that we see with how that's developed in the United States should be a warning there. I think that the risk of creating a special liability regime for public officials is that you end up treating them specially. And I think there's something powerful about the Diceian principle, not just because it emphasizes the equality of defendants under the law, but its equality under the ordinary law, which I think is significant.